Hello and welcome to this training. We're calling this Moot Court Training 101 because it's for those of you who have little to no experience with Moot Court before, or if you'd just like a refresher, maybe you've never competed in Moot Court or maybe even heard of Moot Court at all. I'm here to start you at ground zero. So we're starting all from scratch. If you don't know anything about Moot Court, you are still welcome to try your hand at judging. And the reason is because Moot Court is not really just for those who have an intense amount of legal knowledge and experience. In fact, there was a judge who judged finals who was not a lawyer at all. In fact, was just a computer developer. These people can become good Moot Court judges because they research the packet and because they do their best to understand and pry at the competitor's arguments. So you do not need to be an expert to judge Moot Court. And this training is going to hopefully help you to just understand the basics of what Moot Court is. So the fundamental principle of Moot Court is that you are acting as the Supreme Court. You are pretending to be a justice on the Supreme Court. Now, maybe you say, well, I don't even know much about the Supreme Court. That's what this training is for. But the Supreme Court will hear arguments from lower courts that are appeals, and then they will make decisions. In the process of making those decisions, they will question the attorneys that bring their arguments before the court. They'll pry and question and show skepticism against those sorts of people. So you are going to be acting as the Supreme Court, maybe not this particular individual, but a member of the Supreme Court in round. This is not the actual Supreme Court. This is a Moot Court round, and you will be one of the judges on the panel. Now, what does that mean to be the Supreme Court? The Supreme Court acts as what's called an appellate court, which means they hear appeals. That means that the cases that they hear on appeal are cases that started at a lower court. Think about like a famous case like the case of O.J. Simpson. That case is what we might see in mock trial, where we have witnesses and evidence and opening and closing statements and cross-examination. Those trials happen at the lower courts, the things that I've indicated with orange, district courts and trial courts. Now, if a party loses the case at the lower courts, they cannot appeal unless they believe that some aspect of the law has been violated. So they can't appeal just because they lost. They could appeal if they think that there's been some law broken or some law overlooked. And that's where the Supreme Court comes in. The lower courts will then appeal their case up to the Court of Appeals and then the state Supreme Court and maybe even the U.S. Supreme Court or a district court in the federal system will go up to the Court of Appeals and then will go up to the Supreme Court. So think about it this way. If you were to take your case and appeal it all the way up, not just to the state Court of Appeals, but to the state Supreme Court, the state Supreme Court would then give you a decision. They would say, I agree or I disagree with your case. And let's say that the court goes 4-1. 4 people disagree with you, 1 person agrees with you. That means that the 4 people will have what's called the majority, and they will write a majority opinion. Now, when they write their majority opinion, only 1 person is going to be doing the writing. The other 3 justices are just going to sign on to that majority opinion. And then the lone justice who is dissenting, who's disagreeing, will be called the dissenting opinion, the minority opinion. So the majority and the dissenting opinions are just explaining why they believe that the case was decided the way that it was, or why they believe that the majority was wrong to decide the case the way that the majority had decided it. Now, there's a small wrinkle in this, which is a concurring opinion. I've colored it closer to the majority because it's technically one of these 4 in the majority. If there are 4 people in the majority, it can be any of these other people who didn't write the majority who want to add something else, or say that the majority got one thing a little bit wrong, or say that they agreed with the overall ruling, but thought that there's a different reasoning why that ruling should have been made. So the concurring opinions are the people who are in a minority of the majority. So think about, they're still in the majority of the court, but they're a smaller part of the court than the full majority. Now, if, God forbid, you lost your case in the state Supreme Court, your last recourse is the U.S. Supreme Court. And if you think about it, the person who lost their case is going to be petitioning the Supreme Court to once again hear their appeal. Therefore, the people who were in the minority, the dissenting opinion, that one lone dissenting opinion, that person will be considered representative for the petitioner. So the petitioner will use the arguments that are from the dissenting opinion from before in order to make their claims. They say, look, we think the majority was wrong. We think the dissent was correct. And they ask the Supreme Court to overturn what just happened. In contrast, the respondent are the people who won the last round. They won at the state Supreme Court. And so they don't have anything to do except respond to the petition that's being made by the person who lost. So the respondent's going to use the majority opinion because they said, look, we think that the majority was correct in the lower courts. So there's no reason for us to do anything except say, Supreme Court, just they got it right. Tell them that they got it right, the lower courts. Now, as you can imagine, the Supreme Court has, when they're making their decisions, they have a lot of things to consider. They can listen to what happened below. They can listen to past cases that are similar to the case that they're now dealing with. That balance of things is split into two categories: things that they have to listen to, things that they don't have to listen to. The things that they have to listen to are considered binding. And that would be anytime the Supreme Court has made a majority opinion. Think about it this way. If a previous court has ever made a decision, the whole Supreme Court, in order to maintain predictability and consistency, has to always hold to that same opinion, with very, very, very rare exceptions. So they are bound to follow the decisions of previous majorities in the Supreme Court. Do they have to listen to concurrences or dissents? They don't have to. They could, probably not dissents, but they could listen to some concurrences, but they don't have to. Everything below the Supreme Court, so that includes the concurrences and the dissents, as well as all the decisions from the lower courts, or the lower courts here, are considered dicta or persuasive precedent. What that means is that the Supreme Court could be persuaded by those lower courts, but they don't need to listen to those lower courts. The lower courts may say something that's true, and they could adopt what the lower courts say or what the concurrence had said. But the only thing that they need to listen to is previous decisions from themselves. What does this mean for you? As a judge, when you listen to arguments from the students, you don't need to, but you could, listen to decisions that they cite from lower courts. If it's the U.S. Court of Appeals, the U.S. D.C. Circuit Court, or a state Supreme Court, you don't have to listen to them, but you could. You do almost always have to listen to previous decisions from the Supreme Court because those are binding on the court now. The competitors are only allowed to access a certain amount of things. The packet that we've given them presents questions that they must address, 2 questions for 2 speakers, factual and procedural history, a majority and dissenting opinion from the lower court, links to cases so that they can use those cases in their own arguments, that they can reference only these cases, and then perhaps an appendix which includes other laws. Competitors are not allowed to quote from cases that come outside of this closed universe. There are 2 sides in moot court. As I've already described, there's a petitioner who's asking the court to change what happened below. They're saying we disagree with what happened at the lower court. So they're siding with the dissent in the lower court, and they're saying, court, please overturn the decision of the lower court. The petitioner speaks both first and last in the round and has slightly shorter speaking times because they get the last word. They also have a rebuttal. That's the last word that they get. In contrast, the respondent has no rebuttals. They have longer speaking time and they're speaking in the middle of the round. I'll show you this, map it out in a second. And overall, the respondent is asking the court to agree with what happened in the lower court. So petitioner is saying overturn, respondent is saying affirm what happened in the lower court. So your job, if you side with the petitioner, is to say, I agree, the lower court was wrong. If you think that the lower court was correct, then you'd side with the respondent. Now, in a real live oral argument in front of the Supreme Court, the justices would be up here in the front. Notice that the audience is facing the justices. The reason for that is because the justices are the center of attention. I show you this graph because even though we're not going to be competing in live competitions except for the national championship, I want you to know that the justices are supposed to be the ones who are the center of attention. Now, don't let that scare you if you say, well, I don't want to be the center of attention. The point is that they're supposed to respect you. The competitors are not supposed to interrupt you. They're not supposed to cut you off. They're never supposed to say, I don't want to answer your question. They're not supposed to say that's a weird question. They always must respect the court because the court is the sole authority in the room. In addition, even though we read left to right and the petitioner speaks first, the petitioner is on the left from the judge's perspective and the respondent is on the right from the judge's perspective because everything is about the judge's perspective. The judge is the authority in the courtroom. So here's how a moot court round will go. There's 2 petitioner speeches, 2 respondent speeches, and then a rebuttal delivered either by the first petitioner or the second petitioner. So the first petitioner will cover issue number 1, the first respondent will cover issue number 1, and then their co-counsels will cover issue number 2, and then the rebuttal will happen. Now, both teams have a combined each have 20 minutes to speak, which means that the respondent, splitting their time evenly, will always have 10 minutes, quite long. The petitioner's speaking time depends on how long they take for rebuttal. If they take 4 minutes for rebuttal, out of their 20 minutes, that leaves them 16 minutes remaining, which means 8 and 8 split evenly. However, they could do it a number of ways. They could also take 3 minutes of rebuttal. They could even take 2 minutes of rebuttal. And then they take that out of their 20-minute chunk and do the rest, split the rest of the time evenly. This is not for you to decide. You don't need to know the math. Just know that a moot court round will last about 40 minutes for a preliminary round. See, this is what I was saying about a 3-minute time. If you had 3 minutes for rebuttal, then you'd have 8:30 for the petitioners and still 10 minutes for the respondents. Same thing with a 2-minute rebuttal, 10 minutes for respondents, but then they'd split 18 minutes divided by the 2 of them, 9 minutes each. Okay, how do you start the round? What happens when the round begins? So a clerk will come in and the clerk will check if there are any conflicts, which means, do you know any of the students? Are you friends with any of the students? And assuming that you're not friends with any of the students, then you should be able to begin the round. The courtroom clerk will then deliver this script and you will say, we'll hear arguments this afternoon or evening, depending on when the round is. In case number 26533, David Bronner, President of the United States, petitioner, versus Mark Crosby, respondent. Is the petitioner ready? The petitioner will then say, the petitioner is ready, Your Honor. And the justice will say, you will say, is the respondent ready? And the respondents will say, the respondent is ready, Your Honor. If you are the Chief Justice, then you will want to wait before you tell them to proceed to make sure all your documents are in order. Don't just rush it. Wait for yourself to be ready. Get your notes up. Maybe if you're taking notes on a paper and pencil, get those out and ready, and then say you may proceed. Just so you know, there are 2 judges per round in preliminary rounds and 3 in out rounds. That means that you don't need to worry about if you are not the Chief Justice, you will not need to follow the script and say all these 3 things, only if you're the Chief Justice. Okay, then the round will begin. And what happens when the round begins? There are 2 things that you need to know right off the bat, and then we'll talk about how to be a good judge. First of all, what to know off the bat. One is there's 1 minute of protected time where you are not allowed to ask questions. So the basis of moot court is questions, but you can't ask questions for the first minute. That means if you see that their timer begins with 8 minutes and 30 seconds, don't interrupt them until 7 minutes and 30 seconds or later. If you see their timer begins at 9 minutes, don't interrupt them until 8 minutes. So just keep track in your own head of protected time because they have 1 minute where you are not allowed to interrupt them. Number 2 is verbally grant rebuttal time. The petitioner will ask, we'd like to reserve 3 minutes for rebuttal, or we'd like to reserve 2 minutes for rebuttal. Make sure you're unmuted and say granted, or that sounds appropriate. Anything that you'd like to just say yes, granted. When that time is granted, then they know they have reserved for themselves 3 minutes, 2 minutes, 4 minutes for the rebuttal at the end. Okay, now it's for the time you've all been waiting for. If you know anything about moot court, you know that the centerpiece, the crux of moot court is the questioning. How do you ask good questions to the competitors? A few tips. Number 1, listen well. Pay attention. My hope is that the students, the competitors, when they present their arguments, even if there are some technical things, that they present it in such a way that you would understand if you're listening well. But that means you've got to focus. Don't try to turn off your notifications on your phone. Try to not have too many screens distracting you. Listen as well as you can to hear their arguments. Number 2, pose hypotheticals. Say, okay, that's true in this case. but what if we change something? Would that change your argument? That's a great question to ask them. For this year's case, which you can learn all about by watching our required training video on the case packet, you might say, what if instead of the Fed, this case were about the Department of Homeland Security? Would your arguments change? Those kinds of questions, those hypotheticals, are really good for making the student sit there and think. The next thing is to ask, how far does that principle go? So if they say, we think that economic agencies should be protected, you should say, how far does that principle go? Should all economic agencies be protected? That seems a little bit interesting. You can also ask, and this is something that you don't even need to be an expert to do this. Listen well to the one side and ask the second side what they think about the first side's arguments. So you might say, counselor, the petitioner said this. How would you respond to that? That's a great question. And you do not need to be an expert. If you listen, you can listen to their argument and say, that's a good argument. Okay, let me ask you this. What do you think about what Mr. Blank said, who's the petitioner? Great way. Use sample judge questions. We send you a list of sample judge questions, which is fully for your perusal if you'd like to use it. And you are more than welcome to use those sample judge questions. And finally, bad questions are better than no questions. Please, please, please know this. Students would much rather have their judge ask simple questions like, could you explain that again? Or I'm not sure I understand that. Or even, where did you get that argument from? Or could you explain that using a different case? Bad questions are way better than no questions. Students love questions. So long as you're respectful and asking them in good faith, you can ask as many questions as you want. Which reminds me, you are the judge of the courtroom, which means they have to listen to you. If you have a question and you feel bad interrupting them, don't feel bad interrupting them. Don't apologize. Just say, excuse me, or Mr. Blank, or counselor, and then you can start asking your question. Don't wait until they're done with a sentence. You can butt in the middle. This is your time to make sure that you understand their argument. So if they're going on something and you don't understand, interrupt them. That's always a good practice as a judge. Now, after all the speeches have concluded, you will then say, very simply, the case is now submitted, and that is the end of the round. At that point, you will exit the room and you will fill out your ballot in the judge deliberation breakout room in the Zoom link. Now, how do you fill out a ballot? I'm going to imagine that this ballot is for a person named Cam Pettitor. And if Cam were to have a pretty good speech, you would evaluate him on these 4 categories and give him the following grades. So on knowledge of facts in the law, you're looking for whether or not Cam is it cites a lot of case law, whether he knows the facts very well. And you're scoring him 50 to 100, thinking of yourself as a professor giving out a grade. So you might say, I think you got a B+. I give him an 88. Now, the second question is pretty self-explanatory. How well did he respond to your questions? And let's say he did really well. I'm going to give him a solid A. He gets a 94 for how he responded to my questions. Delivery and decorum is related to how well did he speak and how professional was he in the courtroom. And Cam maybe did not speak very well, had a lot of filler words, so he gets a C+. Delivery and decorum is a 78. Finally, logical argumentation is how persuaded were you that their overall arguments were very solid? And if he gets a 97 because you thought that his arguments were amazing, that would give him an average of 89.25 points. You will do the math yourself. Just punch it in your calculator, add 88, 94, 78, and 97. Add it up and divide it by 4, and you'll get your average points. Basic math. Now, I want to remind you that you're grading this like you are grading a college essay, which means you're not going to give everybody a 60. Don't give everybody a 60. That unless they were all horrendously bad. Do not give everyone a 60. Do not give everybody 99, because unless everybody was insanely good, you're not going to give everyone a 99. There needs to be differentiation. Now, a lot of people have said, I'm a little bit worried because there's such a wide spectrum. Like, what's the difference between an 87 and an 88? It doesn't matter to me. Here's what you need to do. When you fill out the ballot, you should compare each of the categories for each of the speakers. Start the first guy with maybe an 85, knowledge of the facts and the law. And then you say, was his co-counsel better or worse than an 85 or equal? And put in that number. So don't just make up the numbers out of thin air. Draw across the line. Say, was his knowledge better or worse than this other person? Was his opponent better or worse than he was? And how much by? 2 or 3 points, 4 points, maybe it was like 10 points. It doesn't matter. We're not looking at the specific numbers in terms of like, oh, an 85. As long as you're internally consistent, that's all that matters for the purpose of a ballot. Okay, I hope I answered a lot of your questions. There will still be a live training to handle all these and answer your questions. Please come to the live training. You're required to show up 30 minutes before the round. Live training happens about 25 minutes before the round. Show up with any questions, and you can also email them to etong@hsmca.org, and I'd be happy to answer those questions. With that, I am excited to tell you that you can watch the other training videos and prepare yourself even more to judge your first rounds. Again, we are genuinely so thankful to have you judging. It means a lot. Without your volunteer time, we couldn't run tournaments. And even if you don't have a lot of legal experience, you are still immensely valuable to us. Thank you.